hold on.
At the Supreme Court.
Hold on,
the
quickly.
mandamus application. They are right to be heard. That was what the Supreme Court.
Quickly, let me go to Osei kyei-Mensa-Bonsu. That's a colossus when the rules come to play. Yes. First, let's take your view, but without seeking to narrow it to whether the speaker was wrong or right. A quick check, a quick research will show that speakers all over the world, almost everywhere in the world, have been vested with certain powers to issue certain sanctions. And these sanctions could include asking a member to withdraw, and I understand that is when they are making a statement or something of the sort. And they can also include suspension, but a reading around suggests that suspension can only happen after a hearing. What do you say? Now that the minority is challenging the speaker's orders, what's the way out?
Oh, thank you very much. I think that the incident which happened last Thursday and indeed in the morning of yesterday, Friday, certainly brings the name of Parliament into disrepute. It is grave and requires to be dealt with promptly. And the Speaker of Parliament is right to have availed himself of the imperative of Order 34 of the new standing order, which provides that despite anything contained in these orders, the Speaker may refer any matter of privilege to the Committee of Privileges and Immunities for examination, investigation, and report. I think the Speaker has, in view of the incident, directed the immediate suspension of the two chief whips for both majority and minority, respectively, and two other members, namely Alasan Suleiman Atampuli and Jerry Ahmed Shai. Their suspension, as you said, is to last for 2 weeks. Now, the question to ask is from where the Speaker is deriving his authority, as I have heard you discussing.
The Speaker doesn't quote any rule.
In fact, neither the standing orders nor the Constitution grants the Speaker any such authority. The Order 35, which I heard one of your panelists quote, that is on the exclusion of this disorderly member, and he has quoted it rightly when he says that in the opinion of the person presiding over the House or a committee, the conduct of a member is grossly disorderly. The person presiding may order the member to withdraw from the presence of Parliament, and that member shall immediately leave the presence of Parliament and shall not enter Parliament again during the remainder of the day's sitting. So, you see, if an incident happens in plenary,
in the
when
course,
the Speaker is presiding, then the Speaker is clothed the authority to cause the withdrawal of that person from the presence of Parliament, and even that.
Oh, we just lost Osei kyei-Mensa-Bonsu. So let's get him back. Let's get him back. But in the UK Parliament, in the US Congress, in the Australian Parliament, they appear to have these powers beyond simply asking a member to withdraw, but also to suspend. But again, it must be said that in most of these situations, for suspension to happen, there must be a hearing. Yeah, Honorable Osei kyei-Mensa-Bonsu, thanks for joining us back.
Sorry, the line dropped. So I was saying that even if it happens in a plenary where the Speaker is presiding, the order for the member to withdraw from the presence of Parliament lasts for the remaining period of the 24-hour sitting day. It doesn't last for 2 weeks. In this particular case, it happened before a committee of Parliament. And indeed, that order ought to have been issued by the chairman of the appointment committee, not the right honorable Speaker.
Okay.
So that is it. And indeed, the Speaker has said that, stated that even before the Committee of Privileges commences their inquiry, he said that anyone found culpable of contemptuous conduct shall be surcharged for the full cost of repairs and replacement, with deductions made from the emoluments, including the salaries of members, if necessary. Clearly, the Speaker is jumping the gun. And from the top of his head, he's proffering his own sanction.
Whilst we still have you, I want to do quick so I come back to my guest in the studio and also on Zoom. Can you pronounce on the effects or the legal effects of the vetting that happened after the Speaker's orders were issued and brought to the attention of the committee? Is it void? Can those people be sworn in? If they are sworn in, can somebody go to the Supreme Court and get them, removed?
What is the effect of the Speaker's own directive? I think we are all indicating that the Speaker has not only jumped the gun, but he has gone outside the prescriptions of the law to impose his own sanctions. In fact, Order 36 provides the sanction regime, and the Speaker has gone outside that, even before the committee sits. So his own attitude and conduct is really, with the greatest respect, questionable. The good thing for us is that today is a non-sitting day. Tomorrow is a non-sitting day. I would plead with the two leaders, the majority and minority leaders, to have a quick meeting with the Speaker to resolve this matter. Because otherwise it may deteriorate.
The question I asked you, sir, was that once the order was made,
the order is an illegality.
It ought not be disobeyed until it has been properly set aside. That's the rule of law, isn't it?
If the order itself is an illegality, how can anybody apply it?
In the court, we say that even if a judgment is made in error, is wrong, is void, once it's been made, an order is made, the only way to change it is to take the right procedure to set it aside. Otherwise, it must be obeyed.
Is the reason why I'm saying I want to plead with the two leaders to have a quick engagement with the Speaker over the weekend to bring this matter to a resolution before the House commences.
That's good. But what do you say to the minority's position? They say that they don't intend to stage a walkout in this Parliament. If they have a view and the majority disagrees, they will not walk out, they will stay there and enforce it.
We're looking at a situation where the House could degenerate into something else. I think that we have had enough already. So it's coming back to the issue that I brought, that it is time for the two leaders to quickly have an engagement with the Speaker. I disagree with the method applied by the Speaker. His own orders are out of the standing orders. They have no place in the Constitution itself.
That point has already been made, sir.
But we need to resolve it. So let the two of them have a quick meeting with him over the weekend to resolve it.
Did the minority do the right thing when the majority insisted that they wanted to continue with the vetting, to vet extra more people? And the minority says, since we haven't discussed, we haven't agreed, it will not happen. We are not working out, but it will not happen. Were they right?
In plenary, before the House sit, the Speaker usually would have preceding meetings with the two leaders. And sometimes he extends it to the broader extended leadership. I guess what has not been happening is that the chairman and the ranking member, plus a couple of the leaders, are not having preceding meetings. I will encourage them to do that. If they do that, we'll be able to avoid this whole buhar that occasionally blows up.
I need your verdict on the particular conduct, this particular case. The minority is clear that the majority was seeking to add on to the list of people to be vetted, and they disagreed because they had not had a consensus. In the absence of the consensus, they insisted that they won't walk out, they will not participate, but they will ensure that the vetting does not continue. Did they do the right thing?
Something you and I are not privy to whatever discussion that went on. Whether the list was agreed on or not agreed on, I'm not in a position to tell.
No, those are facts that both of them have relayed to us. Mahama Yarga confirms exactly what Habib says.
On the list?
Mahama Yarga confirms it.
That he did not agree on the list. In that case, you have been wrong on the part of the chairman to have insisted. And if it is wrong on the part of the chair, then it would then straighten the path for the minority. But I think the cure for this meeting is to really have pre-sitting meetings and agree on the terms and conditions of engagement every sitting day. Is the minority right to use fiscal force to enforce their protests? I will not encourage physicality, but I will encourage truthfulness and upholding the integrity of the House and the committee. So in this case, they ought to have walked out. I've painted a picture. If you want to give it a title, it's up to you to give it a title. Either they walk out or they sit there quietly without disturbing the process, right? Something. I've painted a picture. However you describe it, it's up to you. Okay. Thank you very much, Osei Kyei-Mensa-Bonsu.